Okay, over to you. Thank you, Stephen.
So what I thought I would do as well, just quickly, I thought, again, just think of people's day jobs, is a few inside tips of how to make your day job easier if you do deal with contentious work in court. Because one of the most useful things I learned from shadowing and now through doing the police hearings is how a party in the court or tribunal can increase their chances of success. Like I said, sometimes there's very thin lines between success and failure of a case, just like there is in an application. So the key thing is that I learned is if you're dealing with anything in court, make it easy for the judge, absolutely as easy as you can, even when not required. If, for example, if you're making an application or any other hearing, produce an indexed, paginated bundle of the relevant documents, and then that means you can then take the judge to the relevant evidence that you want very easily. And then another thing is trying to think it slightly differently, and when dealing with any issue, if possible, focus on what the benefit to the court is. I mean, I know you want to win the application or whatever it is for your client, but if you focus on what the benefit to the court is, if they make the decision in your favor, that's often a good tactic as well. So for example, if the court granted you a certain expert, for example, it would make the judge's job at the final hearing much, much easier because of X, Y, and Z. Because obviously the courts, as you know, and probably more so these days, have a real focus on efficiency, and anything that will, for example, make the trial proceed more smoothly or make the decisions easier for the judge is more likely to be accepted by the court. And I think, like I said, the fine lines, you've got to always be aware of that. And just, again, don't get disheartened. This applies to both applications and when appearing in court. Don't get disheartened with failure, because it's often very fine lines between success and failure. And obviously in courts, it's only on the balance of probabilities, which isn't a very tough burden anywhere. The court only needs to find enough evidence of what is more likely than not. And that's the same in civil cases and police misconduct. So, like your application, again, in court, focus on your really strong points and don't adopt a scattergun approach, because that just confuses the judge if you do that. Thanks for listening, and hopefully we'll have some questions.